Scott Pruitt was elected Attorney General of Oklahoma in 2010. He received his Bachelor of Arts in Political Science and Communications from Georgetown College and a JD from the University of Tulsa College of Law. He served for 8 years in the Oklahoma State Senate, where he was an advocate for fiscal responsibility, religious freedom, and the right to life. As Attorney General, he established Oklahoma's Federalism Unit to combat unwarranted regulation and overreach by the federal government. He brought suit against the Affordable Care Act and remains a zealous advocate for religious freedom and the sanctity of all human life. He is a past president of the Republican Attorneys General Association, and he was even a successful general managing partner of the Oklahoma Redhawks minor league baseball team. Please join me in welcoming Attorney General Scott Pruitt.
Well, that's very nice of Andrew to say those nice things, but also to reference the baseball portion. It's an unusual thing to have someone in politics that's also on the baseball team. So I hear. It happened just a few years ago, right, here in town. But we did own the Oklahoma City Redhawks there in Oklahoma City for a number of years and very much enjoyed my time. Good to see you, Hans. Welcome. I'm very much blessed for many reasons today, but I'm blessed primarily because I'm joined by my daughter, who's actually over at Heritage, staying at the Heritage campus, and very much appreciate McKenna's in the back, so I'm very thankful to be able to see her. She took me to a great dinner last night in honor of Father's Day, and so we've had a good time in town. But I'm excited to visit with you about this issue of the next Supreme Court justice and the role of the court presently as we look to the future. And I think it is a very key and strategic time. And I want to begin by just asking and commenting, there's certain times in history that as we are living them, we know that we're living in a very important time. We know that we're making history for the future. We know that the founders recognize that. We know that the founders recognize that in correspondence and letters to one another about the posterity of that which they were creating. We see that from World War II as well. Just historical moments that we know that the actions being taken by individuals at that time are not just about that generation or about that particular issue, but it's about what's going to occur in the future for many decades ahead. And there are other times in history that are very significant, but we don't recognize them as much. Pope John Paul II, as an example, June 2nd of 1979 was the first pope to ever enter into a communist country. He went back to his homeland in Poland and gave a series of sermons over a week or so period talking about the importance of his countrymen responding to the fabrications that were being propagated by the communist government at that time. In fact, he said two things to them. You're not who they say you are. Let me remind you who you are. Now, at the time, that wasn't in the history books. At the time, there was not much written about the Pope entering into Poland and the significance of that series of sermons. But a decade later, historians look back and said that was the beginning of the Solidarity movement and thus led to the fall of communism. So as we gather here today, as we gather in Washington, D.C., and I always get nostalgic when I come to Washington, D.C., and I look at all the monuments, and I go to the Capitol Hill, and I see Statuary Hall, and I see the great commitment, the great love of liberty that our founders possessed. But as we gather here today, I would ask you the question rhetorically. Is this a time that's an historical moment as it relates to our constitutional fabric? Is it a significant time in history as we look forward into the decades ahead that the decisions that are being made today, are they going to impact liberty to the degree that we've seen historically? And I would say to you that I think that we are living in such a time. In fact, I would say to you that the judicial branch in many instances is the last surviving branch of our constitutional framework. When you look at the executive branch today, it's acting like the legislative branch. You have the executive branch that's using regulatory power to engage in legislative types of action, and thereby creating this imbalance of power between the legislative branch and the executive branch. And the legislative branch is not doing much better either. In fact, in many instances, it's not showing up to work. And I don't mean that literally, but in the passage of laws, it is truly abdicated its responsibility. There's something in the Constitution called the non-delegation doctrine. But yet we see those in Congress routinely doing what? Delegating authority to the executive branch to do its job. There are many examples of that. And so I really think as we look at the judicial branch, it is the last surviving branch because you can go before a U.S. Supreme Court today or an Oklahoma Supreme Court or a court in this country, engage in advocacy, and the court will make a decision. So it is functional. But I'll say to you, we're at a tipping point even in that branch of government as well. And that's what I want to talk to you about today, is that though the judicial branch is still functioning, the question must be asked, will it function in the way that the founders intended into the future? And so that's the reason I think this discussion about Justice Scalia, the replacement of Justice Scalia, is such an important question to ask and answer and to address today. Now, I got a chance to know Justice Scalia personally. He was someone that I have a good friend, Leonard Leo, who's the executive vice president at the Federalist Society. And Leonard blessed me on numerous occasions to spend some quality time, personal time, with the previous justice. In fact, I remember one year, about 3 years ago, I was up here for a Federalist Society event, their annual meeting that occurs in November. Leonard said, "Scott, stay over. I'd like for you to go to dinner on Friday night. And anytime that Leonard asks you to go to dinner, you stay because he feeds you well." But as I went to dinner on that Friday night, there was somewhat of a surprise. We went to a basement here in Washington, D.C. There was about 10 of us in attendance. 2 of those folks in attendance were Justice Scalia and Justice Thomas. And we spent 3 hours talking about the Constitution and things that we were involved in as attorneys general. It was a fabulous time. And Justice Scalia was a person of brilliance, great intellectual prowess, as you know, but he was also very witty, very charming, and very personal. We lost a patriot when Justice Scalia passed. But I want to say to you, as we look forward, and I'm going to share with you about 5 principles, 5 things that I think Justice Scalia represented in his jurisprudence that literally transformed how we think about the law today. But before I get there, I want you to know this is not just about a vote. I think oftentimes we look at the Supreme Court and we hear the debate going on in Congress and the U.S. Senate taking the position it's taking, the president taking the position he's taking presently. This isn't just about a vote on the U.S. Supreme Court. That is important. We've seen that as recently as last week. This is about an attitude, a spirit, a belief in what the judicial branch should be focused upon in the future. And Justice Scalia, I think, was 5 things that I think I can share with you today that really demonstrate the importance of an individual on that court and how they can make a difference in the trajectory of that branch of government and its impact on our liberties and freedoms. And so I'm going to mention to you 5 things today that I think that will draw attention to that. The first thing is that Justice Scalia was a textualist. And you sometimes hear that term and you think it's the same thing as original intent, and it's not. Justice Scalia was a textualist in the sense that he believed that the text of the law, the text of the Constitution, should control the outcome. And that sounds rather simple today. That sounds rather straightforward. But before Justice Scalia was appointed to the U.S. Supreme Court, and he began this endeavor of focusing upon textualism, most courts, if you look back before 1987, that was a foreign concept. That a judge felt like that they were constrained, that they were restricted in issuing a ruling based upon the actual words of a law and the actual words of a constitutional provision. They believed that they were able to add what? Their own beliefs, their own view of that language, and therefore we saw a progressive mentality that took root in the jurisprudence in this country. But Justice Scalia changed the trajectory in a substantial way. In fact, Justice Kagan, she was quoted as saying that we're all textualists now. That's the impact that Justice Scalia had on this debate. And though it does sound simple, and though it does sound straightforward, it has had a profound impact, I would say, to the point of General Meese, when he served as the Attorney General for President Reagan, began the discussion about federalism. And the concept of federalism was something that had kind of been pushed aside. General Meese revived that, and I believe that Justice Scalia also didn't revive textualism, but he gave it a meaning in life in a way that has made a difference into the courts since the late 1980s. And what is textualism? Well, textualism effectively is we look at the law as written, and we apply the law as written. We look at the words used and give meaning to those words. And if there are any gaps, We don't simply just fill in the gaps. And if they lead to bad policy, Justice Scalia was notorious at saying it's not our jobs as judges to make a bad law a good law, to do the job of Congress. And so that textualism means that sometimes there are outcomes that you may find offensive from a policy perspective. I've had many examples as Attorney General, as I have taken actions to enforce the statutes as drafted by our legislative body. There are many times as I've looked at I don't agree with the policy of the law. I don't agree with what the legislative branch has done, but that is not my job as an Attorney General to pick and choose which laws I choose to defend. My job is to carry out my responsibilities of the Constitution to enforce and execute the laws that have been passed by the legislative branch. And Justice Scalia would say the same thing as a judge. Give meaning to the words, give meaning to the text, and even if it leads to quote unquote a bad outcome, it's not the job of the judge to fix that outcome and to address the bad policy. We've seen this live and in color recently. In fact, Oklahoma was the lead state in the state healthcare exchange debate. And that followed, as you know, the original ACA, NFIB versus Sebelius, was a constitutional type of case that challenged facially the authority of Congress to even pass the Affordable Care Act. They have the authority to pass it under the Commerce Clause, which, by the way, just a side note, the Supreme Court said no. We forget that. The Supreme Court said that Congress did not possess the constitutional authority under the Commerce Clause to pass the ACA. The whole issue there was Chief Justice Roberts found that they could under taxing power and use that to justify the law's existence on its face. But we followed up with that, a case dealing with the state healthcare exchanges, where the Congress set up this framework between federal and state exchanges, and if states didn't set up a state exchange, guess what Congress said? Subsidies could not be issued in those states. Tax credits could not be issued to offset the rising cost of healthcare. And so that was the literal language. That was the literal impact of that law. And when we challenged it, we lost that case before the U.S. Supreme Court, largely, in my opinion, because of the policy outcome of people would not have access to subsidies. So Justice Scalia spoke very assertively in the dissent about that very issue. So the point I'm trying to make with textualism is that it's not a matter of do we agree with the policy, do we agree with the outcome. The job of the jurist is to look at the language and give meaning to life to the actual words used, and that's it. The second thing that leads to that, the first one leads to the second principle that I think Justice Scalia utilized, in that he was an originalist. Not only was he a textualist, he was an originalist, but not in the way that you might think. We hear a lot about original intent in our discussion with respect to the judicial branch and jurisprudence. But Justice Scalia was an originalist in the sense of saying the words that were used must be interpreted, must be understood as they were understood at the time that the law was passed. It'd be like you entering into a contract and to buy a home or to buy a business or to engage in some sort of transaction, you enter into a contract, and then there's a dispute about some aspect of that contract. And then there's a litigation that occurs. When you go before the court, Justice Scalia would say that the provisions, the terms, the language used in that contract should be understood at the time the contract was drafted, even if it was 10 or 15 or 20 years ago, and not to be reimagined, not to be reinterpreted based upon the language and the understanding of those words today. And so that's the way he was an originalist. And that combination of textualism and originalism is very powerful with respect to his focus on the role of the court and recognizing the third principle that I think is terribly important, and that's respect for rule of law. And rule of law is something that I know that oftentimes when we hear it, maybe not in this room, but I think in society, that we think it's a quaint concept from the 18th century. We think it's an academic or a legal principle, and it's not that important. Rule of law is essential to how we do business as a country. Rule of law means that laws are stable. They are static. And as a citizen, you can look at that law, whether it's constitutional or statutory, and you can take confidence that that is a static expectation of you. And you can plan accordingly. You know, there are certain portions of the tax code that I don't like, particularly the percentages of what's expected of me. But I can look at that statute, I can look at that law, and I can say that's what's expected of me from an obligation as far as taxes, and I can plan accordingly. I can set money aside. I can take money out of my pay. Whatever it is that I need to do to comply with that particular expectation, that rule of law allows me to plan and allows me to govern my life accordingly. Now, the opposite of that is the inconsistency of not being able to look at a law as static. And it's interesting in today's legal context, and I deal with this every day as Attorney General. I can mention many cases to you where this is the case, where a regulatory agency, after the fact, after a law is passed, will take a statute that is plain and ambiguous and say, we're going to reimagine, we're going to amend. Now, they don't call it that, but that's their action. They execute a rule to change the language of a statute. It's happened innumerable times. It's happened in the ACA context. It's happened under the Clean Air Act. It's happened under the Clean Water Act. The Waters of the United States case that we were just involved in as a collection of states, I led that effort. It was a reimagining of what constitutes the water of the United States for one fundamental reason. The EPA wanted authority, jurisdiction, power over decision-making on how you use your land. And so that's an example of an individual or a business being governed by a regulatory body that changes a statute after it's passed, thereby injuring rule of law. And what does that create? Instability and uncertainty. We have many issues, just a sidebar comment. Fiscal policy, tax policy are all very important to our ability to grow an economy into the future. But I would submit to you the greatest impediment to economic growth in the country today is regulatory uncertainty and regulatory power. And it can truly be described as an abuse fundamentally of rule of law. And so Justice Scalia, by applying textualism, by applying originalism, would say to you that leads to a respect for rule of law. It leads to a respect of those that represent us in Congress. Have you ever thought, and I mentioned this to my folks in Oklahoma, again, a sidebar comment, why is federalism so important? Why are these issues of rule of law so important? One, it creates this confidence, and it allows people to plan and deploy capital and hire personnel and the rest. But Oklahoma, you all probably don't know this off the top of your head, we have all of 7 people here in Washington, D.C. representing us. 2 U.S. senators and 5 congressmen. Now, I would ask you a question rhetorically. If we yield a decision to Washington, D.C. that should be made by the state of Oklahoma, either under the Constitution or the statute that Congress has passed, we suffer because 7 individuals representing us in Washington, D.C. are never going to be able to compete with Illinois, Ohio, Texas, Florida, California, New York, all these large that have a factor of 7 that represent those states. And so the founders understood that. And they understood the importance of rule of law. And when Congress gives primacy to the states, as they did under the Clean Air Act, or the constitutional framework through separation of power, or excuse me, through separation through federalism, gives the right to the states, and it's disrespected, then it injures rule of law. And Justice Scalia, I think, recognized that in his jurisprudence in a very meaningful way. So that's the third thing that I would share with you, is that textualism and originalism leads to respect for rule of law. It's not a living document. It's not a breathing document, the Constitution. It's not a document that allows jurists on the U.S. Supreme Court to discover new rights. But to do what? To apply the text and recognize the rights given through the actual language. Now, many of the cases that we see of late that have caused such a disruption and such an outcry across the country are rights that have truly been, quote unquote, discovered through what? The 14th Amendment and substantive process. And so that's the reason Justice Scalia was so, opposed to this judicial philosophy of discovering new rights, and it's not a living, breathing document, and the effect on rule of law. And the fourth thing that I would share with you as far as principles that Justice Scalia represented, and this is a meaningful one. All these are, but this one to me particularly, enumerated rights were unequivocal to Justice Scalia. There were no exceptions. And again, it follows his philosophy of textualism and in originalism, but let me tell you what that means. That means that he joined the liberal side of the court in rendering decisions. The flag burning cases. Justice Scalia joined the progressive on the court to say, look, the free speech is an enumerated right, an enumerated power, and he recognized the right of individuals to burn flags. Very unpopular, and very unpopular with conservatives particularly. The Fourth Amendment, there was a case, Maryland versus King, where the state of Maryland was collecting DNA samples upon individuals who were arrested but never charged. And Justice Scalia spoke assertively, again, with the liberal wing of the court to say that was inconsistent with the Fourth Amendment. Obviously, Justice Scalia was the author of what? The Heller decision, the Second Amendment. And that shows you how important his replacement is going to be. That was a 5-4 decision. That fifth vote is obviously not on the court anymore. But he wrote the opinion in the Second Amendment. The Confrontation Clause. Justice Scalia, again, this is all under enumerated rights, were non-negotiable to Justice Scalia. The Confrontation Clause of the Constitution that says that you have a right to confront your accuser. A state passed a law, the Crawford case, that said that because the accuser was a minor, that the accused could not confront that person. Justice Scalia joined with the 4 liberals of the court to say that was inconsistent with the Constitution. So the point I'm trying to make is that all flows from what? Textualism and originalism, and he gave meaning, life, power, if you will, to the enumerated rights of the Constitution. And then I think the other area that the fifth comment I would make about principles that governed Justice Scalia's philosophy, judicial philosophy, and its importance as we go forward, is he was a constitutionalist. And what I mean by that is he was a structural federalism person. We hear a lot about federalism, but structural federalism is something that we need to understand with it. The founders separated powers horizontally. We all get that. That's fifth grade civics, between the branches. But they did something else that is as important. They separated power vertically. They enumerated power for the federal government and reserved power to the states and to the people. And in that vertical checks and balances, that vertical checks and power, along with the horizontal checks and balances, that's structural federalism. That's something that as we look at it, the founders believed that was essential to preserving our liberty for the long term. And that is something that I believe that Justice Scalia represented very much in his opinions. The very last thing that Justice Scalia did, I don't know if you know this or not, was to issue a stay in the Clean Power Plan case. I was actually a part of West Virginia and Oklahoma were part of the decision to seek the U.S. Supreme Court's intervention to stay the EPA's enforcement of the Clean Power Plan that was adopted, finalized by the EPA. And we estimated there was about a 15% chance of winning. The last week of his life, Justice Scalia joined with 4 other members of the court and issued a stay. It was unprecedented. And they did it largely, in my view, because of a case that happened the year before, Michigan versus EPA, which we were also part of that. It dealt with mercury and a mercury rule, and the EPA was required to go through a cost-benefit analysis in that rule. Did so, but the cost-benefit analysis didn't really play in their favor. There were billions of dollars of cost, and this is not an exaggeration, billions of dollars of cost and millions of dollars of benefit. And so the EPA just brushed it aside and said, we're going to adopt the rule anyway. State sued. Took us 3 years to get before the U.S. Supreme Court and get a victory in 2015. Guess what happened in the interim? The EPA forced that rule upon utility companies and citizens throughout the country. And so practically they achieved their outcome, yet they lost the case. The EPA bragged about that post the decision, and they really did, in press releases. In fact, they actually said, yeah, we lost, but we accomplished our goal anyway. I think that particular case is what drove the court to intervene in the Clean Power Plan case, and Justice Scalia led that intervention. So that federalism notion, structural federalism notion that I'm making reference to, was demonstrated as recently as the Clean Power Plan decision. I think as we go forward, we've got to ask the question next, not just what principles did Justice Scalia represent in his jurisprudence and how he set a trajectory that was important for the judicial branch, but what's at issue as we go forward? Constitutionally, what cases, what issues do we think are going to be impacted by who replaces Justice Scalia and whether he or she possesses these characteristics, these principles that I referenced? And I think the first area I would mention to you is religious liberty. Hobby Lobby is a case that you may have heard about. The Hobby Lobby business is located in, the corporate headquarters are located in Oklahoma City. David Green is a good friend of mine. But if you follow that case, you know that Hobby Lobby was a Supreme Court decision that stands for the proposition that corporations actually possess rights under the First Amendment, free speech and free exercise rights, privately held corporations. That was the distinction that the court offered, not publicly traded. And I can unpack that for you in question time if you want. But we've seen several cases come before the court. Little Sisters of the Poor, this term, came before the court. No resolution, actually sent back to the district court because of the 4-4 split. And that case is still being litigated with no outcome. We had a case, certiorari was denied recently. A pharmacist was objecting to the requirement that he issue or sell abortion-inducing drugs. And the pharmacist said, that violates my First Amendment beliefs. And the state of Washington said, to get a license to be a pharmacist, you must do this, or you won't be a pharmacist. In the state of Washington, he sued, lost. The Ninth Circuit ruled against this individual, sought certiorari before the court, and unfortunately, cert was denied recently. So when we look at the religious liberty context, whether it's in the Hobby Lobby context, the Little Sisters of the Poor, or cases like the pharmacist case that I just mentioned, we can see that religious liberty is going to be a very important issue going forward. And I would submit to you this. There is a real vigorous debate that's ongoing about what does the First Amendment actually protect with respect to free exercise. And the debate is this. The debate is that some believe that we have a private faith, that we have a right to worship, and that's it. We don't have a right to engage, to exercise, that the free exercise language in the Constitution just simply gives you the ability to gather on Sunday or Saturday or whatever day of worship you have, and you have a privatized faith, but to engage in the public square, that's not something the First Amendment protects. I was in Romania in 1997, traveling there, and spent some time with a church leader there in Timișoara, which is where the revolution occurred. And I was going through the church with this individual, and up on the wall there were pictures of pastors from the 1950s and 1960s. And I was confused. I asked the individual, I said, did you meet during the 1950s? Did you meet during the 1960s? And the individual said, yes, we met every week. But as we met, there was always someone in attendance from the government who monitored everything that we said. And if we went outside the four walls of the church and shared what we learned within the four walls of the church, we were arrested and prosecuted. That's what I mean about the protection of right to worship versus the right of engagement. Religious persuasion, if you will, in the public square. That is going to be an issue going forward, and we already see it taking place. Those cases are before us, and they're happening. And this person, whomever this person is that replaces Justice Scalia, the question must be asked, are they going to look at the First Amendment as an enumerated power, enumerated right that is unquestioned, as I shared that he did in other instances? Are they going to look at it from a textualist perspective and an originalist perspective, as I've already shared, in determining whether you and I have free exercise to engage in religious persuasion in the public square? We don't have a right not to be offended, by the way, in the Constitution. I think some are trying to interpret that way, but that is going to be a very important matter going forward with the court. Second area, also in the First Amendment, is free speech. We know that with Citizens United, there's a continual drumbeat here in Washington, D.C. with respect to Citizens United and corporate participation in the electoral process. Let me dispel an untruth. It happens at times in the political space. Citizens United does not stand for the proposition that there's unlimited giving to a campaign. That's not what Citizens United says. Citizens United doesn't say that a corporation can give unlimited amounts of money to a candidate. It says that a corporation, which legally is seen as a person and always has been under our laws, has the ability to engage in expenditure to voice their opinion about either an issue or a candidate in an electoral process. It's called independent expenditures versus what? Contributions. And there are many in this debate that blur those lines to try to say that a candidate is receiving the unlimited resources of a corporation to get elected to a particular office. And that's just simply not the case. States and the federal government have the authority to cap or limit the amount of contributions. But what the Supreme Court has said is that there's no authority that the government possesses to cap free speech. And that's what Citizens United equals. And that is a case that is going to be front and center into the future as it relates to decisions. We already have 4 members of the court that are willing to overturn Citizens United, clearly. We have 4 members of the court that are I think, postured to overturn Heller. So we know in the religious liberty context, whether it was Little Sisters of the Poor, Hobby Lobby, or in the denial of cert in this last case, that there are 4 to limit, contract, privatize the view of the First Amendment as it relates to free exercise. So these are very important cases we go forward. The other case that I've mentioned in the free speech context is the Friedrichs case that was also impacted this particular session and this term. A case out of California, a non-right-to-work state. Teachers there in California, they wanted to make sure that as there was compulsory dues that were being paid to the union, the teachers union in California, and those dues were being used to advance what? Issues that were contrary to the beliefs of the individual teachers. And so there was a suit that was pursued by those teachers to say, that's a denial of my First Amendment rights. Unfortunately, that case was lost before the Supreme Court this particular term. So I think as you look at the First Amendment, as you look at free exercise and free speech, prospectively, the importance of who replaces Justice Scalia and the principles that they embody will make a huge difference in the liberties and freedoms that we have in the future. Now, I do want to say that this issue, again, is not just about a vote. Things in Washington sometimes, they're simplified to a point of saying this is just about a 5th vote on the U.S. Supreme Court. Clearly, a 5th vote matters in these cases. But again, I think as important is attitude and belief in what the judicial branch's role is in our constitutional framework that Justice Scalia represented. I think that there was a persuasion that Justice Scalia offered to other colleagues on the court that we never knew about, that we never saw. I believe that he had many discussions with Justice Kennedy about certain cases that perhaps influenced his opinion or his ultimate decision with respect to some key cases. Justice Scalia's passing is not just a vote. I think his true impact on the court is going to be felt for generations ahead. And I'm hopeful that we can put somebody on the bench that represents those principles. Otherwise, we will see an imbalance, a court, a judicial system that has become our ruler, which is inconsistent with what the founders intended that branch of government to be engaged in. So it has been a joy to be with you here, and I know that we're going to have a time of question, if I'm not mistaken, question and answer. How much time have I taken? Too much or too little, or about right? Okay, yeah. So about 15 minutes or so of Q&A. So I think I get a chance to play TV host here and just take questions and hopefully answer them. Well, hey, Chuck, how's it going? Do you mind if I get this gentleman right here first real quick? Because he had... Sure. Yeah. Hello, Matt. How are you?
Hi. Just a quick question for you. Thank you again for your comments. This is very interesting. What are your thoughts about the 17th Amendment, the repeal of the 17th Amendment, and Scalia's thoughts regarding that?
Well, I mean, there are a lot of things that are being discussed right now. I think that are all the way, including an Article 5 convention, that are, I think, are important to the debate that we see. I'm actually supportive of a repeal of that. I think it's important. I think as close as we get to what the founders' vision equaled is essential to the future of Washington working the way that it should. I mean, from an attorney general perspective, many folks think that our cases that we've brought against the federal government emanate from the 9th or 10th Amendment, and they don't, most of them. Most of them are simply cases that are about statutory construction. They truly are examples of an executive branch doing one of two things. Either pinch hitting for Congress, which is the immigration case. You've heard the president say, I've got a pen and a phone, many times. And the president in the immigration context said, Congress has not acted. Congress has not acted the way I want them to act, so I'm going to act in their place. 27 states join together. We get to respond to the executive memoranda and get the stay that I referenced. And then we have other instances that I've talked about today, which is statutory language that Congress has passed that the executive branch is trying to reimagine and reinterpret to its own end. So there truly is an attitude in Washington that the states are mere vessels of federal will. And so long as they act in accordance with the federal government's view under each of these pieces of legislation or constitutionally, things are fine. But when states actually engage and exercise the authority that they possess, that's where the conflict and the tension rises. And I think that particular amendment is one that goes to the heart of what those individuals in the U.S. Senate are there to do. And they're there to do what, primarily? Give voice to the state's interest in this debate, this discussion about federalism and the role of Washington, D.C., and the primacy of the states. And so do I have much hope that will occur? I don't know if you've got any kind of, Yogi Berra, I mentioned the baseball reference. Yogi Berra one time said, predictions are pretty tough, particularly about the future. And so as we look at those kinds of issues and try to predict whether that's possible or not, we shouldn't engage in that probably, but I'll do it anyway. I don't see much, I don't have much optimism that that's going to occur, but it's a good question and one that I would answer the way that I did. Chuck?
Yes, sir. Thank you for being here. I agree with you.
Doesn't it feel good in here, by the way? I mean, it's just glorious in here, right? I mean, it's cool and it's warm outside. I just feel it's refreshing. Thank you for having the air conditioning on about 65. It feels good. I mean, this is like home to me. I mean, I walk in at home and I like to have it on about 68, despite what President Obama thinks I should be doing on cost. That's the reason I want coal to keep being burned across this country so I can have low electricity rates and I can keep it at 68. I'm sorry, Truck. I diverted.
No.
I digressed a little bit. Sorry.
No, this doesn't address Justice Scalia, but more the bigger picture, which is what you talked about as far as the rule of law. And I think that's what separates the United States from many third world countries. And we have a justice or injustice department at the federal level that, as you mentioned in the previous question, likes to impose its will on the states. They want to enforce certain laws, and they don't want to enforce other laws, whether it's about traditional marriage or about drug laws. They sort of pick and choose what they want to enforce. And I guess my question is, at what point, given the example of our federal Justice Department, do citizens actually start picking and choosing what laws they want to obey if law enforcement is picking and choosing what laws they want to enforce? Well,
I don't agree with you and I are on the same page here. The attitude of the Justice Department, and we've seen this with state attorneys general as well, very close to here, the Virginia Attorney General and also the California Attorney General. So this is something that state attorneys general are engaged in too. But I'm not one of those that believe that I have some sort of preference or prerogative to pick and choose which laws I defend. I'll give you a great example. When I came into office in 2010, I was elected in November of 2010, sworn in January of 11. I inherited a constitutional amendment to our Constitution, Oklahoma State Constitution, dealing with Sharia law. And the language was clearly not going to pass constitutional review. We knew that. I mean, I looked at it and I told the legislators who passed it privately, this is something that's not going to survive. And I don't really think the way that you did it was the right way to do it. But guess what, Chuck? We went to the courthouse and we put on the best case we could. We advocated as best we could, and we got beat. But that is not even what you're talking about. You're talking about a situation where those in the executive branch, attorneys general at the state level or our Justice Department, from a policy perspective, are saying, I don't agree with the policy of what that law says. And so therefore, I'm just simply not going to do what? Defend it. And that is absolutely 100% wrong. And it's a bad example, and it causes confusion amongst the electorate, I think, about how those things should be done. I'll mention a case that's not terribly popular, particularly, I mean, I'm good friends with the folks at Cato. We hang out together on some issues, but they've not been terribly happy with me about my lawsuit against Colorado with respect to marijuana. And I'm going to take this opportunity to share something with you about that case because it is relevant to Chuck's question. We have a law at the federal level called the Controlled Substances Act, right? And that law designates marijuana as a controlled and dangerous substance, correct? Now we also have a Supreme Court case that says that the Controlled Substances Act is constitutional under the Commerce Clause. Now, whether you agree with that or not, we have a Supreme Court decision and we have a federal law that says what Colorado was doing, the trafficking of marijuana across state line and use of possession internal to the state is what? Unlawful. There are federal felonies being committed every single day in the state of Colorado. Now, as a good constitutionalist, I did not challenge that portion of their law with respect to use and possession, the decriminalization of possession within the state of Colorado. We challenged, as a state, only that portion of Amendment 64 that dealt with the commercialization of marijuana across state line. They're exporting marijuana to 36 states across the country. Over 2 tons of marijuana has been exported from Colorado since they passed it. We seized 85 pounds of high-grade marijuana in Custer County 2 days after my lawsuit. The point I'm trying to make is I have said to those at the federal level, repeal the law. If you want to effectively address, if you want to legalize, if you don't want to prosecute in this area, because the Justice Department has chosen not, there's been instruction to U.S. attorneys across the country, don't prosecute that crime. So for a state like Oklahoma, who has not legalized use, possession, and trafficking, and you see just a flood of marijuana coming into your state, what do you do as the chief legal officer? Just turn the head and say, we're not going to do anything about it? Or do you give meaning to the statute and what the Supreme Court decision is? Now, again, that's my job. It's not a policy decision that I'm making. And sometimes people interpret those kinds of actions, those kinds of lawsuits as being an opinion about whether, the efficacy of legalization or decriminalization with respect to marijuana. And that's not what I'm doing. I'm simply trying to protect our state's decision and give meaning to the laws as passed by Congress and the state of Oklahoma and Colorado. But despite all that, it's a very, very controversial thing. But that's why, this issue, Chuck, is an important one. Because you have the federal Justice Department in the immigration context, what do they say? Categorical exemption, not prosecutorial discretion. I use that every day in my office. Discretion of a prosecutor is to look at the facts, the law, make a decision about whether I prosecute. Case by case, right? It's not to look at a statute and say, we're just going to lop that part off and 5 million people, you're good. That's not discretion. That's rewriting the law. And that's what the court said, by the way. So this is a very important thing that you've brought up, Chuck. And I hope that we have a attorney general in January of 2017 that has the right view of their job and not this policy-driven view of their job that I think has started to dominate the discussion and bled over into states' attorneys general. I got off a little bit there. I'm sorry. I got to preaching a little bit, got into marijuana. Those things. I didn't mean to do that. Forgive me. Yes, sir. Well, I thought you had a question.
Hi, my name is Howard Segermark.
I'm sorry?
My name is Howard
Hello, Howard.
Segermark. Would you discuss a little bit about the attack on property rights and the effect of that attack on the other rights of American citizens.
Do you have any specific areas that water, asset forfeiture, any particular areas that?
Well, EPA comes to mind.
Okay. Well, the one that's most salient, I think, example of in response to your question is the Waters of the United States rule that was passed by the EPA, proposed and finalized. That was a direct attack on private property owners across this country. And if you're not familiar with that case and you're not familiar with that rule, historically and legally, the EPA has authority over waters that are what? Navigable. That's what the statute says. The courts have said. And the EPA didn't like that constraint. They don't like to be controlled by Congress. They like to pontificate and reimagine things, as I've already indicated. So they issued a rule that changed the definition of what constitutes a water of the United States by saying that so long as there was a nexus to navigability, then they had jurisdiction. So what did that mean in Oklahoma? Well, in Altus, Oklahoma, southwest Oklahoma, we have a lot of dry creek beds. We've had drought conditions there for the last 7 to 8 years. It's where the Air Force Base is located, by the way. And so 90% of the year we may have a dry creek bed, heavy rain, standing water. 10% of the year we have water in that dry creek bed. The EPA was asserting jurisdiction over that dry creek bed. So that if there were any land use decisions being made, farming or ranching, oil and gas, building a subdivision, any of those actions that you've taken historically. In fact, we had examples of individuals who had thousands of acres who simply wanted to build a pond on their own land. And it perhaps impacted one of these dry creek beds before they could build a pond on their own land, not for commercial purpose, not for anything like that. They had to go to what? The EPA to get permission to use their own land in that way. That's how impactful this rule was. We challenged that. 31 states, we led the effort there. 31 states challenged that. We won that case and got a stay of enforcement against the EPA. They were reimagining what constitutes a water of the United States under the law. So that's an example of the attack. And look, that was about one thing, in my opinion. It was about power. It was about jurisdiction and the authority of Washington, D.C. to determine how we're going to use our land in Oklahoma or every state across the country. And that's just so incongruent, inconsistent with the framework that we've described and we know that the founders created. So it's been great to be with you. Any more questions? Can I take one more question? Because this lady, two more? Oh, you got a question, or you give me a signal? Okay. So, I thought you were giving me a signal. You're like my third base coach when I was playing baseball. I never could figure out what the guy was saying. He'd do this and do this, and I didn't know if I was supposed to bunt, steal or what, but hit away.
So one thing Scalia was noted for was the Chevron Doctrine, and actually creating a lot,
right? Yeah.
Creating a lot of deference to agencies, and that seems to be one of the really big questions. So I was curious if your thoughts on what people should think about with regard to administrative law for the next.
Yeah, we all make mistakes, right? So I think that Justice Scalia was dialing back he wrote an article, law review article, I think in 1989, 2 years after he had been on the court, speaking very favorably about the survivability, the longevity of the Chevron. Now, he was actually not on the court when Chevron was decided, as you know, but he spoke very favorably about Chevron and then reinforced it in some decisions afterwards. I think it is one of the singular most important issues that we face from a regulatory and administrative law perspective. This idea that agencies, just because of who they are, receive some sort of tipping of the scales in their favor in carrying out the responsibilities as given to them by Congress. Chevron deference, in my view, should be overturned. Congress should speak to it. I know there's something called the REINS Act that's being proposed and discussed in Congress. That doesn't go necessarily directly to Chevron deference, but look, when you combine delegation and deference in the regulatory state we have in this country today, we don't govern ourselves anymore as we should, in my view. There are two things that need to happen. Congress needs to do its job, actually send people to Washington, D.C. that understand their role is to legislate. Legislation is hard work. But legislation should not be, we like clean air, so go make clean air. What do y'all think? I mean, that's something that bothers me, is that Congress then gives to the EPA this general grant of authority, and then what happens? EPA issues rules that we find oppressive, we find intrusive, we find we don't like them. And what do the congressmen do? They go back to Oklahoma. We've got good ones. I shouldn't say that. They go back to other parts of the country and they say, we didn't do that. The EPA did that. And so it gives them clean hands, quote unquote, to basically delegate their authority in the way that the founders never intended. So the courts need to get serious about enforcing the non-delegation doctrine, which emanates out of separation of powers, number one. And number two, the court needs to overturn Chevron to say that as those agencies engage in regulatory action, they don't get this get out of jail free card, deference, you guys are great, so the scales tip in your favor. No, they don't get a chance to use Chevron deference to do what? Change a statute, change the language. It's frustrating to me because we deal with this firsthand. I mean, we sit in my office and we look at cases and we say, can we overcome Chevron? And they've clearly acted in ways that are inconsistent with the language in the statute, but the courts are going to begin with this attitude of saying, well, they win if there's a tie. In fact, I would tell you this, it's even more than that, right? You guys have to do more. They are so trusted. They're so believable. They're so credible. We love them so much that they're going to get the benefit in this proceeding. So, look, if I had an opinion, that's what I would say. Chevron deference should go away. What do you think? Thumbs up? All right, thumbs up. And we have one other question. This young lady here. I missed a Nationals game last night. Every time I've come into town, I've looked at the schedule, and I've wanted to go watch a Nationals game. I've never been to Nationals Park. I've gone to all these parks across the country, and I hear great things about your park here. And so my lovely daughter takes me to dinner last night because it's Father's Day, and she treats me to a wonderful, wonderful meal. And then I get back, and one of my staffers say, I went to the baseball game. And so I had this just conflicted, maybe we should have gone to the baseball game, McKenna, I'm not sure. But I want to go check out your all stadium because I hear it's wonderful. Is it good? Have you all been? You haven't been? Maybe we should go. Yeah. Yes.
In your talk, you mentioned that Oklahoma, because of the number of people, has only 5 representatives in the
U.S. House.
Representatives. My question to you would be, what do you think about statehood for the District of Columbia, where the citizens have absolutely no rights? They can't vote in national elections. They can't even have any control over their own budget, including from money that they received from D.C. income, not from the federal government.
I would say to you a couple things. I haven't really given a tremendous amount of thought to that, as you might imagine, but there would have to be a great deal of persuasion deployed to convince me that D.C. needs to be a state. And maybe that could occur, but I'm not for adding any more states at this juncture. For several different reasons. But that's just where I start, and maybe I could be persuaded otherwise, but it's just not something that I've thought a lot about. I hear what you're saying as far as the representation in Congress, but it's something that I would start from a premise of saying no more states until we learn more about it.
But how would you feel if it happened to Oklahoma?
Well, I wouldn't like it, but we became a state in 1907, and I'm really focused upon making sure that original charter, our equal footing into the union is respected by the courts in Washington D.C. It's just not. I mean, honestly, it's just not something I've spent a lot of time thinking about. But I'm just being very honest with you. It would take some persuasion to convince me that we need to add another state, D.C. or otherwise. So perhaps you can do that over a baseball game. And can convince me of that. Yes, sir.
Walter Weber, American Center for Law and Justice. One of the problems, as I see it, with the federal overreach is that they've got the states on the dole.
States what, I'm sorry?
On the dole. The executive branch can say, do it our way, or we're going to yank your money. And I'm afraid that as long as that steady flow of money from the states to D.C. and then back out to the states continues, the states will always be in a position where they could be intimidated. Is there any way of undoing that?
Well, look, I mean, the court addressed that to a certain degree in the NFIB versus Scalia. In fact, it did address it with the Medicaid aspect. I mean, the governors across the country that are making decisions about Medicaid expansion didn't even have that right until we brought the lawsuit. Our claim there was that the decision about Medicaid mandatory expansion violated spending power. It was a gun to the head. It was coercion. It was intimidation. It was an entire change of the program that Medicaid historically, the people that it served, and we won that portion of the case. But it did highlight, to your question, the importance of the decision that states are making, whether it's in the transportation context, but particularly in the education context. There's only one state in the country, I think it may be Nebraska, could be the state of D.C. in the future, I'm not sure, that rejects federal monies for education. And they have obviously none of the requirements and mandates that Oklahoma faces as a result. So I think states do need to take a serious look at whether the bargain that's being struck between the federal government and the respective states to take money, it comes with a price. And I would say to you, it comes with a substantial price. And it comes with a price that honestly, if you look at the bargain and actually put numbers on the paper, I know in the education context, it's a loser for Oklahoma. The mandates that are forced upon the state of Oklahoma, get funded about 20 to 30%. And so we're picking up about 70% of those mandates. So it's a fair question to say, then why are we doing that? I think it's more of a choice, though, and less a legal issue. We really don't know at this juncture how the court's going to apply NFIB versus Sebelius. How are they going to look at this gun to the head coercion type of, we don't know if it's, focused upon the definition of the program like it was in FIB as far as Medicaid and its purposes originally, and it was an unmooring that occurred through the mandate. Is it monetarily driven? If there's so much money in play that and the Feds say you must do this, does that qualify as violating spending power? So I think the development of NFIB versus Sebelius in the spending power context is yet to be. It's going to occur over time, but I think in the first instance, states really need to look at whether this bargain that they're engaging in with the federal government is a valuable one. I think it's a good question. We see it in the transgender case that just arose on May 13th when the president issued or the DOE issued the significant guidance with respect to transgender students. And just this aside comment, that's another area that we see great problems in the regulatory framework is guidance versus rulemaking. We've seen it. I've seen it firsthand. We had banks in Oklahoma when I first came out. Within 3 months of being in office, I had a community bank, and I can't recall the community, maybe Ada or Ardmore. I can't recall where it was in the state, but the FDIC came in and said they had issued a guidance document on overdraft protection. And as they were going through an examination with this bank, they fined the bank for noncompliance with that guidance document. I found out about it, and I sent a letter to Sheila Bair, the chairman of the FDIC at the time, and just simply said, last time I checked, there's something called the Administrative Procedures Act that says that guidance is not rule, and went through the entire explanation. They quit doing it. But that's what happened with the transgender situation. Significant guidance by the Justice Department and the Department of Education reimagining what constitutes gender under Title IX and the 1972 amendments to the Civil Rights Act. And guess what's at issue? About 12% of the money in Oklahoma are those dollars. It's about $500 million. So the federal government is saying to K through 12 and higher ed in the state of Oklahoma, with respect to dormitories, with respect to locker rooms, with respect to athletics, with respect to bathrooms, which is what gets the most attention, you do these things or else. I think there's a spending power issue there and a potential violation that we're going to prosecute in these cases. So your question's a very good one. I think in first instance, the states need to evaluate the merits, the bargain, the policy decision on whether to engage in that negotiation with Washington, D.C. For money. The court has talked about it. The court has talked about it many times and of late, and I think the court would say, look, states, y'all need to, I think they'd say what I just said. You need to look at this situation and whether it's good for you or not. But if you do, the feds do have an ability to leverage you to a certain degree. The question is, are they leveraging you too much? What other questions do you have? I think I'm getting the third base coach here saying that it's time to stop. So.